The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court, from recess, now sitting.
Thank you. Please be seated. Turn to the fourth case on this morning's docket. That is case number 102036, State of Kansas v. Marlon Williams.
Marlon Williams appears through counsel Michelle Davis. Chief Justice Nuss, may I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. This is a case from Wichita, Kansas, where Mr. Williams was charged with recruiting a young woman named L.M. under the age of 18 years old, basically to engage in prostitution, sexual acts for hire. And he was charged with recruiting her outside of a house in Wichita and then transporting her for that purpose. And the state charged Mr. Williams with a new statute, aggravated human trafficking, as a result of his actions in Wichita. And we raised several issues in our brief. The first is that the aggravating trafficking statute itself is unconstitutionally overbroad, that it's vague. And then we also raised a couple of sentencing issues on the basis that the state here could have charged Mr. Williams with promoting prostitution as a result of his actions, which basically covers the same sort of behavior, which would be the recruiting and the transporting. And so as a result, Mr. Williams should be charged under the lesser penalty provisions because the sentence for aggravated trafficking is quite severe, high-level felony, versus promoting prostitution, which is a lower-level felony. So the first issue then, I'll try to go in order, is that the aggravated human trafficking statute is unconstitutionally overbroad. And the reason that it's overbroad is because the statute prohibits, the way it was charged in this case was recruiting, transporting by any means LM under the age of 18, knowing that LM with or without force will be used to engage in the sexual gratification of the defendant or another. And I think primarily the statute is overbroad because of the last part of that sentence, which is a sexual gratification of the defendant or another. The district court in this case said that the state basically upheld the statute, saying that the state can criminalize people who try to encourage children in sexual activity. But this statute doesn't prohibit sexual activity per se. In fact, it doesn't even prohibit that the child would be used to engage in any sort of sexual act. It simply prohibits engaged in sexual gratification of the defendant or another. And so basically it's our contention then that that language covers any sort of sexual thoughts where the minor participates in an act in which the defendant or another is sexually gratified in their thoughts. And so I think that is the core problem with the statute here. Obviously, there's some language in the Court of Appeals opinion that says that the legislature passed this statute in order to target sexual exploitation of children.
Does your client fit within your hypothetical? I mean, isn't what your client engaged in much more specific than that? I mean, you're basically asking us to make a determination based on a hypothetical situation that doesn't apply under the facts of this case.
Yes, that's our overbroad argument, that in targeting activity, speech, and association that is not constitutionally protected, for example, encouraging someone to prostitute, the statute also targets speech and rights of association that are constitutionally protected, that is our overbroad claim. This statute is unconstitutionally overbroad, and because it primarily targets speech and association that is constitutionally protected, that therefore Mr. Williams has standing to bring this claim to this court. because of the chilling effect. The case law that says that that then has a chilling effect on speech and association just by the law's very existence, because it targets constitutionally protected speech and activity.
Why was the Court of Appeals wrong when they determined that the activities that you've hypothesized are not within the target of the statute, so that they don't meet the test of being a significant part of the target, which is the first prong of the overbreadth test?
Well, if you read the plain language of the statute, then all of the things that I've hypothesized in my brief are plainly covered by the plain language of the statute. It basically says any sort of speech or any transportation of a minor, knowing that that minor will be used to engage in the sexual gratification of the defendant or another. So, I mean, all of my hypotheticals meet that language. And
But the case law is pretty clear that almost any statute can be read and so that there are things that would impede on speech or other First Amendment rights, but that's not where we stop. We have to take a reasonable reading of the statute and the purpose of the target of the statute and examine that. And so if the target of it is the sexual exploitation of a child, why is that not?
because the statute doesn't say that. For example, the federal statute says the child will be caused to engage in a commercial sexual act. The federal statute, the federal sex trafficking of minor statute says that. It specifically covers sexual exploitation of children.
But
The way this statute's drawn, you have to then read that language in. You're saying you want to read this statute so it only covers the sexual exploitation of children.
But is using a child for sexual gratification a sexual exploitation? I'm not.
That would require you to read that interpretation into the statute, not from the plain language, but from the way you think that the statute should be written.
I'm not sure I understand that. If the statute says use for sexual gratification.
So what does sexual gratification mean? Okay, the state says gratification means pleasure.
That's your vagueness argument, right?
Well, yes, but part of, if you look at, for example, one of the cases I cited, Reno versus ACLU, the fact that the statute contains vague language can be considered in determining whether the statute is overbroad, whether it's specifically tailored to meet the conduct that the state is trying to prohibit and that it can prohibit. So the fact that it contains vague language simply adds to my overbroad argument.
Help me understand standing then, because for vagueness you do have to have standing.
Well-
as in, as applied to your client, it has to be vague, and I don't think that you even argue that.
Right, but the fact that there's vague language in the statute still goes to my overbroad claim.
So we
I'm not
just
making-
can't divorce them, is what you're saying.
Yes, I mean, there's cases that I've cited that, like, for example, Reno versus ACLU, that say the language in here is so vague. And I can get there's ambiguities concerning the scope of coverage means that it lacks the precision that the First Amendment requires. And that's exactly what I'm talking about here. There's ambiguities regarding what this statute's trying to prohibit, because the very language, sexual gratification of the defendant or another, is so vague. It's so ambiguous. It's the expression that they used in that case was burning the house to roast the pig. It's covering so much that's not the point of the law, because sexual gratification of the defendant or another is so broad. It's so vague. That could be anything. That could be. My example in the brief was watching the cheerleader perform. I mean, that's an example where there can be sexual gratification. Going on a date with somebody can be sexually gratifying. There's all kinds of conduct here that the statute could prohibit that's not considered sexual exploitation of children. there's so much speech and there's so much association that we wouldn't consider to be sexual exploitation of children that can fit within this statute, primarily because the statute doesn't prohibit an act such as a commercial sexual act. If it prohibited an act, then that would certainly narrow it down. So it doesn't require, I argue it doesn't even require any act between the minor and the adult. All it requires is knowing that an act by the minor will lead to sexual gratification by an adult. So that encompasses a lot of conduct that isn't sexual exploitation of a child, unless you want to consider cheerleading to be sexual exploitation. That's why when you say a reasonable interpretation of the statute, you would have to read something into the statute to narrow it down to conduct that would be considered sexual exploitation, if you want to call that a reasonable interpretation. But that's you making that interpretation. That's not the plain language of the statute that is providing that interpretation to us. So because the statute is overbroad, Mr. Williams does have standing to challenge it. I think the difference here, for example, the state and the Court of Appeals relied on Whitesell, which was the stalking case. But in Whitesell, for example, stalking, there's no First Amendment right to threaten people. Criminal stalking requires a threat that you are going to convey a fear of harm to someone. You're communicating harm. There's no First Amendment right to threaten people. So in Whitesell, they said that, so obviously, I'm not trying to say that all speech is somehow, that's protected. There's obviously certain speech that's not protected. And so in Whitesell, they said that this is not the type of speech or conduct where you're threatening people. This is not the type of speech or conduct that's protected by the First Amendment. The difference in this case is that you'd have to read into the statute some sort of harm to or sexual exploitation that's just not to be found there, and that's the difference. That this encompasses a lot of speech that is protected speech because it's not trying to encourage criminal activity. It's not threatening somebody. For example, our solicitation statute. If I was going to solicit someone to do a criminal act, that's not protected speech because you're encouraging, it's inciting. You're inciting, you can't incite somebody to criminal activity. That would not be protected speech. But in this case, the way the statute's drawn, it doesn't limit speech to only unprotected speech. It covers a lot of protected speech.
I ask you a quick question
Sure.
about your specific versus general.
Okay.
Why can't you view the human trafficking as being more specific with regard to minors? Because promoting prostitution doesn't require that you be dealing with children. As between those two statutes, the human trafficking is more specific with regard to children. You understand what I'm
The
asking?
aggravated trafficking has the element of age within the statute itself versus promoting prostitution has the age as a sentencing penalty.
Yeah. The aggravated human trafficking is dealing only with individuals under age 18, right?
Or two other circumstances, right?
Yeah.
So,
So my question is when you're looking at the two of them and dealing with children, why isn't it more specific the statute that deals with protecting the children versus the one dealing generally with prostitution?
well, because they both prohibit the behavior with a child. One simply does it through the substantive law itself, and the other does it through the sentencing penalty. But you both get to the same place. I mean, that doesn't distinguish between the crimes. I mean, the doctrine is about the type of conduct that's involved.
So specific versus general deals with the activity, not with with respect to the victim.
Well, that's part of it. That's
Except
part
when
of
you
it.
have incest is more specific than aggravated indecent liberties, and that's because of the relationship of the victim.
Yeah, my argument in this case is that the prostitution is more specific because it talks about a specific sexual act instead of sexual gratification, which is a very broad term. The promoting prostitution has a specific act, and in this case it was specific sexual acts that were alleged. And then it also talks about for hire, which is a specific way of being used. If you want to think of being used, hiring somebody is a specific type of use. And so therefore it would be, and I just want to clarify also that Court of Appeals in this case said that the difference was that in the promoting prostitution you have to be transported within the state. But that language is in the promoting prostitution statute and it's not in the aggravated trafficking statute. But
What
Kansas-
cuts against you is just what you mentioned, is that you have to have for hire. You have to have an exchange of value with regard to prostitution. With regard to human trafficking, all you need is the sexual gratification. And so I'm having trouble getting to the identical elements if you're looking at the elements rather than the facts of this case.
Right, but if you're talking about the identical offense doctrine is the facts in relation to the elements, so given the facts in this case as they relate to the elements, then they are, because under the facts of this case it's the same. I'm not sure if I'm answering your question, but
the
based on
element,
the facts of this case, it would be strictly elements, no, but as the facts are applied to elements. I'm sorry, Justice Luker.
but it is our focus is on elements. Haven't we said in Cooper and other cases that what we're looking at is whether the elements are the same to the extent of the overlap? We have several elements in one that's not in the other, don't we?
I agree, and you would have to read used very broadly, used and for hire, as being used as such a broad and open term that it could include for hire, which is obtain the use of. That's correct. It's just how you read those terms. So I just want to clarify, though, that whether this was the transporting within the state or not just is insignificant because Kansas wouldn't have jurisdiction. I mean, he's not charged with driving somebody in Texas or what happened in Texas. Kansas wouldn't have jurisdiction over that. So whether just because promoting prostitution says you're transporting within the state, and ag indecent liberties doesn't use the word in the state, it's just transporting, it's all implied. I mean, every statute is implied it's taking place in the state. That was the reason that the Court of Appeals said that they were not specific general. That's the reason why they denied that claim, because as you pointed out to Age, in one of the statutes they said, well, one statute has in the state, transporting in the state, but that just doesn't matter because both statutes require that, whether it's stated or not.
Do we have any further questions of counsel? Thank you.
Thank you.
May it please the Court, Assistant District Attorney Matt Maloney. I will primarily focus on the overbroad and vague arguments and be happy to answer questions about any of the other issues. With respect to the overbroad challenge, I really don't know that I can add much to what the Court of Appeals expressed in their opinion. I think their opinion was very consistent with what I argued in the brief. The overbroad test does have two components to it, and simply put, I don't believe that the defendant can get past the first part of that, in that he would have to show that the protected activity that he's pointed to in these various hypotheticals is a significant part of the law's target. As the case law reflects, and as Your Honor pointed out in questioning defense counsel, almost any statute can be subject to interpretations where you could say that it's overbroad, that it applies to something that shouldn't be criminal. I cited in my brief the Wilson case where the defendant was that was making the argument about the child endangerment statute and arguing that it could be used to apply to parents who allow their kids to play football. And clearly the court indicated that that was not a reasonable interpretation of the statute to suggest that that was actually a significant portion of the law's focus. Another hypothetical that I used.
And why did Wilson do that? How did it accomplish that? It read language into the statute unreasonably endangering.
Right. And I think, I used also an example of in my brief, you could, if you want to go down the road that the defense is going, you could say that you could use it to apply a battery or an aggravated battery charge to anybody that plays hockey or in any boxing match or in any ultimate fighting. There's all kinds of scenarios where you can hypothesize that in these certain scenarios the statute could be considered to cover that, but clearly I think you have to take a common sense approach and say that this is not a significant part of the law's target. Likewise, in this case, when you're talking about things like asking a child on a date or the cheerleading example, I don't think that by any interpretation of the statute or that there's any legislative history indicating that that is the target or let alone a significant part of the law's target.
But how do we look to that? Don't we have to look to the language of the law to know what the target is? And where is that in this statute?
Yeah,
it seems to me that Ms. Davis has made a fairly decent point that the Court of Appeals read the sexual exploitation intent into the statute when it's not real clear that it's there.
I think when you look at the language of the statute in its entirety, and it talks about first of all, it does talk about sexual gratification, and it does say that when the minor is used for the sexual gratification, and I believe the Court of Appeals opinion in addressing the vague argument sets forth the commonly accepted definition for those two terms. I would argue that language in the statute itself does support and essentially matches up with sexual exploitation. I think that when it says that the child has to be used to engage in forced labor, involuntary servitude, or sexual gratification, used, as the Court of Appeals indicated, is defined as to bring or put into service or action. I think that, to me, takes it outside of a situation where the defense is arguing with, for example, the cheerleading situation, where it's kind of the child is just engaging in this activity that he or she would otherwise be engaged in. He or she is not being used by anybody. They're simply, in the cheerleading case, the cheerleader is simply doing what an otherwise normal activity. And apparently the hypothetical that the defense is getting at would be that somebody watching that performance may get some sort of sexual gratification from that. But I don't think you could say that in that situation the cheerleader is being used, is being put into action or service for purposes of the sexual gratification of the offender in that situation. In that situation, the child would be very much just a passive, unknowing participant, would just be going about her normal routine, and somebody happens to get some gratification. And I don't know that activity would fit within the definition of the statute when you look at the statute as a whole.
Are you aware of any legislative history that explains the choice, why they chose to use the term sexual gratification?
I'm not aware of any. Not to say that there is none that exists, but if it does, I did not find it when I was doing my research on this. So I don't have anything to enlighten you with respect to that particular word choice.
Seems like most of the other states' statutes, and as counsel said, the federal, deal with the activity of the child victim. The commercial sexual activity is a frequently used term, and this has to do with the state of mind of someone else that's not even involved necessarily. And it it does seem to be more broad than at least the majority of statutes that I've seen.
Sure. Well, a couple of things. I think first to just circle back to my argument about the phrase will be used. I think that use implies something more than just a passive participation by the victim. I think that does indicate that conduct of the victim is part of the statute. And secondly, I guess to the extent that you do find that it is more broad than perhaps other states would be, that obviously wouldn't answer the question of whether it's constitutionally overbroad. The fact that perhaps the legislature could have defined it differently or better doesn't mean that there's a constitutional problem with the way that it was drafted. So I think with respect to the overbroad argument, I think I've made my point as clearly as I can, that I simply don't think that there's that the activity, that the hypotheticals that the defense has put before the court would be a significant part of the law's target. Turning to the vagueness argument, I did argue in the brief that this argument isn't properly before the court because it was not raised before the trial court, and furthermore, the defendant lacks standing to raise the vague issue. There is a distinction between vague and overbreadth. Overbreadth arguments are generally allowed, even if the defendant is not saying that they specifically caused an issue in his case, but for vagueness arguments, it is a stricter requirement, and he has not alleged that his conduct that his particular case is affected by this vagueness argument. So I think that the court does need to keep those two. I understand that counsel has argued that there's some overlap and that they need to be looked at together, but I don't think that that's sufficient to allow the defense to overcome the lack of standing on the vagueness issue. If the court does elect to entertain the merits, I think that the Court of Appeals opinion very well does a very nice job of speaking to that issue. The words in the statute. Sexual gratification is also used in other portions of the Kansas statutes, and I think you can look at the case law, the interpretations given to that phrase. And as for the word used, I think that it's such a common term. To me, it seems like the defense's argument would almost require the legislature to specifically define every word in a statute in order to avoid a finding of vagueness. Used is a word that is commonly used in everyday language, and I don't think that anybody could reasonably say that word somehow prevents a defendant from understanding what conduct is prohibited by the statute. And finally, I think the last issue that was touched on today was the general versus specific. I think that this court pointed out the correct focus in questioning defense counsel, which is that the focus is on the elements. And the question isn't whether under a given factual scenario, both statutes could be applied to a certain defendant on specific facts. You have to look at the elements and see whether one statute more specifically deals with the same. I think in one of this court's opinions that I cited in the brief, it talks about how the general versus specific test applies when the statutes apply to the same identical conduct. These statutes, when you line them up side by side, there are so many elements in A that are not in B and vice versa, that you really would have to be almost reading the elements completely out of the statute in order to determine that they apply to identical conduct. Yes, there certainly are situations where where a defendant's conduct could be prosecuted under both, and I have no doubt that in those cases the defendant would prefer the severity level 6, but the elements of the statute diverge so much that it does not appear that they would apply, that they are aimed at the same exact or the same identical conduct. And again, I think the Court of Appeals opinion does a nice job addressing that, and I don't have too much more to add to what the court's already spoken with counsel about. So if there are no further questions, we would simply request that the defendant's convictions and sentence be affirmed.
Why does turning to the prosecutorial misconduct argument, why does the prosecutor's statement to the jury that the defense has a subpoena power not shift the burden to the defense?
Right. Well, I think that, first of all, it is relevant, although I'm not implying that the prosecutor has free rein because her comments were in response to defense counsel's argument, but that is part of the analysis that goes into it. And when you look at defense counsel's closing, counsel did use closing argument basically to say the state didn't prove their case because they didn't present all of these other witnesses, and they just didn't have enough here because they didn't bring in this parade of people that could have bolstered the victim's testimony. And really what the prosecutor was doing was not shifting the burden and saying that the defense was obligated to present witnesses to support their defense, but was simply pointing out that the defense is also entitled, also has subpoena power, also has the ability to present witnesses. Essentially, it was just saying it's not a one-way street for the defense. I think that the defense's argument could easily have suggested to the jury that the state alone had the power to put witnesses before them, and that because the state failed to do so, somehow they hadn't proven their case. And the prosecutor was simply reminding the jury that both sides have the ability and the power to present witnesses before them. And I think really the defense's argument was simply trying to take issue with the quality or quantity of the state's evidence, and the prosecutor was simply responding to that. And I don't think that it was tied to any indication that the defendant had a burden to present those witnesses, but simply reflected that the defendant had the ability to present any witnesses that he chose.
Assuming we would disagree and think that that comment did shift the burden, would you address why you would say it would not be a reversible error?
Well, first would be just the fact that it was an isolated comment. It wasn't a theme that the prosecutor returned to consistently or at all during her closing argument. Second of all, it was on rebuttal, and I think the recent case law indicates that the reason why that is a factor in the analysis is because it obviously weighs against a finding of ill will or gross or flagrant when the comment is something that's made extemporaneously in response to an argument that the prosecutor is kind of responding to on the fly, as opposed to something that is stated in the initial portion of closing argument where the prosecutor clearly had unlimited time to come up with her arguments and phrase them in an appropriate manner. So I think both of those things would weigh against a finding that it was gross or flagrant, let alone ill will. And finally, I would just rely on the strength of the evidence in this case to say that there's little or no possibility that the isolated comment would have made a difference in the jury's mind. I think that it's always telling, though it doesn't preclude review. I think that the lack of an objection in these contexts is always telling, because it shows that the comment made so little impact on the minds of the people that were in the courtroom, including the defendant's own attorney, who was there to protect his rights, and yet that person didn't find it objectionable. And it's only with the benefit of a limitless amount of time to review the record that sometimes those of us in the appellate world can kind of come up with scenarios where a comment might be improper. I don't think a jury listening to that would have noticed the comment to any degree that would have affected.
And if defense counsel would have thought that was improper, how would he or she have helped his or her client? By pointing out the statement, by objecting and getting a limiting instruction to reinforce the statement one more time. I mean, how could defense counsel have cured an improper statement?
Well, it's a fair question. I think that my response would be attorneys are put in that situation all the time at trial, whether it's a misconduct claim or whether it's an evidentiary objection. Defense attorneys and prosecutors alike always have to make that decision. Which
is my point with regard to using it to minimize the egregious nature when you have a strategic decision that has to be made that doesn't affect preservation.
Right.
Then I think you're pushing the envelope to use that to say, well, defense counsel didn't think it was bad, so you don't need to think it was bad. If it's preservation, I understand if that's a point or enticement to make that. But when it's the matter of strategy, if I object to this, all we're going to do is make it the focus here, and I'm going to reinforce it, and I'm not helping my client any.
Right. Well, and I think one thing that comes to mind, and it doesn't necessarily apply on our facts because this was an isolated comment and it was not a repeated theme, but I think that one reason why perhaps the lack of an objection in general should still be considered in the analysis is in cases where perhaps there is an allegation on appeal that there were repeated instances of misconduct.
Before you continue on that, my notes indicate that there was an objection.
With respect to that particular
Yes.
comment, then the record certainly, I do not mean to misstate the record. I did not have that specifically in my notes while I was preparing for the argument. So to the extent that it was, then clearly that portion of my argument does not apply on these facts, and I would obviously apologize for any indication that I might have misstated the record.
How would that change your argument or your answer to Justice Luker's question about the harmlessness of it if the court put its stamp of approval on it?
Those, as I review records on almost any case I work on, it's a question that I have a lot, because I think a lot of times you see comments in closing argument that are objected to, and more often than not, the response that I see the trial court give is to essentially say, this is just arguments of counsel, it's not evidence, and they just move on very quickly. I rarely see a court ever sustain an objection, although it does happen occasionally. I still think that the ultimate analysis then would come down to whether the comment had any impact on the result of the trial, or whether there's any indication to think that it would have affected the jury's verdict. And again, just pointing to the isolated nature of the comment, the fact that it was made extemporaneously in response to defense counsel's argument, and the strength of the evidence in this case, I think it would be beyond hypothesizing to think that the jury somehow had their verdict affected by the fact that the prosecutor simply pointed out that, hey, the defense is free to call whatever witnesses they choose to call also. I think, first of all, that probably what the prosecutor said is something that would probably be something that the jury would have already been aware of anyways, that the defense was free to present witnesses on their behalf if they chose to do so. So even if the court does find that isolated comment was burden shifting or somehow an error, I don't think that it was gross or flagrant or that it showed ill will, and I certainly don't think that it would have denied him a fair trial by affecting the jury's verdict.
Here, the judge actually made a finding or a conclusion, I'm not sure which, that it did not shift the burden in response to the objection. Do we give that determination by the trial court any deference?
It's an interesting question. I don't know that this court necessarily is bound in the context of a misconduct claim. I suspect that the court is entitled to obviously consider the statement and in light of what the case law tells us about burden shifting and what is or is not allowed. I don't think that I would be so bold as to say that you're conclusively bound, obviously, if the district court's finding was an error. But I do find that the court's finding, though, is I agree with it, and I think that obviously the Court of Appeals did as well, as finding that this was not burden shifting. So I think it's, while perhaps not binding, it is something that I would ask this court to adopt the same finding because I do think it's supported by the facts in this case. I don't think that this case rises to the level that you typically see in a case where the courts have found that the prosecutor shifted the burden to a defendant by making a statement during closing arguments.
Any further questions? Thank you, counsel.
Thank you.
Just briefly, I know that the Wilson case, the football case, was brought up, and in the football case, the Wilson case, the statute says unreasonably causing or permitting a child. And because it said unreasonably, that's where the court said that the interpretation of prosecuting someone for allowing their child to play football would be, they said it would be a strained interpretation. Courts will not give strained meanings to legislative language and a common sense interpretation. But the difference in this case is I'm not asking you to give a strained interpretation to the statute. I'm not asking you to hypothesize something that the plain language of the statute doesn't cover. It says used. Whatever used means, however you want to interpret that. The state at the district court said that meant victimized, argued that meant victimized, so that made the statute okay. But once again, that's not a strained meaning. I mean, if to read victimized into that would be the strained meaning. What I'm asking you to do, reading the plain language, is not strained. There's no strained interpretation here. This prohibits any sort, transporting or recruiting a minor for any sort of engagement with anyone where there's going to be some sort of sexual gratification of the adult. There's nothing strained about that. I mean, it's right there in the plain language of the statute.
How do you address the argument of will be used that in certain of these innocent activities that you proffer, it would be strained to say that the defendant is actually using the child to do that rather than the child happens to be engaged in that activity after being transported? Do you understand what I'm saying? Or I understood the argument that has some meaning, that the defendant is actually using the child rather than just permitting the child to engage in protected activity.
So I think what I'm understanding you to say is that the state's argument is that the statute has to be read to mean that the defendant would be using the child, and the statute doesn't say that. So, again, you've got lawyers in the district court, you've got a prosecutor saying this means victimized. You've got a defense lawyer saying no, used is just used. Like we talk about, we're using somebody, I'm using them to get a ride, I'm using them for sexual gratification, whatever use it is. And so, again, if you just go with the plain language here, it's a strained interpretation that would have to make this lawful, that would have to make this statute constitutional, would be the strained interpretation. We require this court to add in all kinds of language. That concludes my comments.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. We now turn to the fifth case on this morning's docket. It's case number 106103, State of Kansas v. Todd D. Schumacher.
If it please the court, Chief Justice Ness, I would request 3 minutes for rebuttal time if needed.
30 minutes is granted.
Thank you. Other justices, first I would point out that on May 2nd, I wrote a letter to the clerk under Supreme Court Rule 6.09b. Justice Moritz had a decision that was handed down. I used the WL site. It's the State v. Stimick, S-T-I-M-E-C case. The site's 297 Kansas 126. Basically, this is a tragic situation where a lady was killed. an individual by the name of Todd Shoemaker, after having multiple buttons pushed, decided he was going to go to his ex-wife's house, kill himself on the front porch so it wouldn't be a mess to clean up, and end his life, and make sure that this Ann Shoemaker had this vision in her mind the rest of her life. And the evidence shows that at the time he went over to the house, he waited until after normally the kids would be gone at school. And the neighbor's car that took him to school in the little town of Leota was gone. But unfortunately, the children were there. And one daughter, Miranda, had a camera. And when she heard her dad and her mom arguing at the front door, she turned the camera on primarily to capture the conversation. Mr. Shoemaker was standing outside the front door of the house, down. Mrs. Shoemaker was standing, Mrs. Ann Shoemaker was standing up about 12 inches higher than Mr. Shoemaker when she answered the door. Part of the video, the whole evidence case here revolves around the comments that Mr. Carr made in rebuttal closing. And I have the greatest respect for Mr. Carr. We've had a lot of cases. And it pains me to use the language I have to use from the cases, but I believe he was improper what he did. While he may have had a good faith basis, it was totally in error. But in rebuttal, Mr. Carr says he's holding this gun and he's cocking it. And he's telling the jury, listen to the sound of cocking on the gun on this recording. I object. I say, Your Honor, I object. That's not in evidence. We go up to the bench, and the judge ruled that because the recording was in evidence, Mr. Carr was allowed to ask that question, and the jury could decide it. But I submit to you, one of the greatest rules there is no rule is governing oral argument is more fundamental than requiring counsel to confine their requests to matters in evidence, under State v. Bradford and all the cases afterwards. And of all the state's witnesses, there was even a Zachary Carr from the KBI, a firearms examiner that examined this pistol, said that it was in working order. It needed 3.5 pounds to pull the trigger. The trigger couldn't be set off by a sideways motion waving around, and that he had handled all these firearms. He was never asked, Sir, let me play this recording for you, and will you listen, sir, and tell this jury, do you hear the sound of what could be the clicking of a gun? Never asked of him. No fact in evidence ever asked of any witness. The officer that collected the gun was never asked, Sir, did you take this gun and listen to this recording, and will you cock this gun and see, do you hear a cocking noise? And the problem with that is when the state said this in rebuttal closing argument, you just went through the argument on what the law is and how the prosecutor's statement has to be outside the wide latitude, whether it's plain error, and then in the second analysis, was it gross and flagrant, misconduct shows ill will, and whether there was direct and overwhelming nature of the misconduct likely to have any weight in the mind of the jurors. In this case, the daughter of Mr. Shoemaker, who had to witness this tragedy, said her dad grabbed her mom, pulled her to him, took the gun, stuck it to her neck, and shot her. That was her testimony. I didn't cross-examine her. She believed she saw whatever she said. The coroner testified that Mr. Shoemaker had to have been the gun at least 1 to 3 feet away from Mrs. Shoemaker when it went off, because there was no stippling in her neck. And the coroner in the record testified that the gun was from front to back, left to right, which was consistent with Mr. Shoemaker saying he knew he caused her death. His issue was, what responsibility should I have? And he said when he pulled this cocked gun out that he had stuck in his belt that had 1 live round that was set to fire, it also had 5 shells in it that were empty. And it's the same gun that 3 months earlier a suicide attempt he thought had happened. And we put on evidence about how he was found with the same gun. This was Mr. Shoemaker's way out. And the coroner testified that no, the shooting wasn't consistent with what Miranda testified to. It was consistent with he could have pulled the gun out, and when it was pulled out, it went off. And it went from front to back, left to right. And she was up. She died. Mr. Shoemaker goes in. And the problem is the first question of the jury, after about 2 hours of deliberation, the judge instructed him on first-degree murder, second-degree unintentional, and then 1 other unintentional. And the question of the jury, which is in the record, was something to the effect, well, we're divided. 6 want premeditated and 6 want unintentional. Does that mean we have to find him guilty of second-degree unintentional? That was the first question. The judge then said, I have to refer you to the instructions. The jury then went back, and what did they do? The 6 people that were for unintentional played the recording over and over and over and over. And finally, one by one, they thought, well, it was clicking of the gun.
Where's that in the record?
Well, it's in the record on the motion for new trial. And
Did you have affidavits? Or?
no, I don't have affidavits. While statements of counsel aren't evidence, this is the old courthouse on the 3rd floor, no elevator.
We don't have anything in the record to establish that.
I have it in the record that the judge and Mr. Carr went and talked to the jury, first the judge and then counsel, and we were supposed to have an opportunity. While I'm loading my stuff in my car, I had to be taken down the stairs, and I had several carts. The jury's leaving, and so I didn't get a chance to interview them. But the judge and Mr. Carr all talked to the jurors, and they told them, and it's in the record. They played that tape over and over and over.
I'm asking, do you have an affidavit in the record from the judge or from the prosecutor saying that the jury told them this?
No, I don't, but I have statements of counsel on the record that I'm supposed to have candor to the tribunal that I repeated to the judge, but he told me because I didn't get my chance to talk to the jury.
This is, the judge told you, this is your characterization of what the judge told you that you put in the brief.
Yes, and I put on the record the motion for new trial. The judge said the jury played it over and over. And the one juror that was in the courtroom crying, I put her name in the brief. She was the last one to change her mind. And it was all because of the recording. And so to say it had no effect or weight, and the reason I gave you a little bit of other evidence is, this isn't a case of overwhelming guilt. This is the case of, was it intentional or unintentional? And the jury deliberated over that for several hours. And the problem with this is, Justice Moritz, is when Mr. Carr made this statement, you can look through that record, and you can look through the 2,037 pages of discovery, and I thought I missed something, and that there was some report that they had done this. No, but if you look at my Exhibit A, which is the motion for new trial attachment, had there been a question asked of any of the state witnesses, does the sound on this tape, this clicking noise, is it consistent with cocking the gun? What would we have done? We would have put on an expert. But you take this exhibit number A, and what does it say? On page 261, the record on appeal, this officer on April 29th says, the video moves about the room, and the camera's microphone scuffs against objects, causing noise to partially cover the voices at times. And what's that noise? Click, pop, click, pop, click, pop. And you can't tell if that's a clicking of a gun or clicking of the door, clicking of the scuffing. You don't know. And then he goes on to say, the expert, on page 262 on the record, that on May 12, 2010, I began working on the audio portion of this investigation. And 49.42 seconds into the file, right before the gunshot, he says, until that time, the female teen holding the camera scuffs the microphone as she moves and causes noises to be recorded, making the voices of the male and female talking at the door difficult. What are the noise? Pop, click, pop, click. And you see, there was no questions asked of the witnesses that the state put on. Is any of this popping or clicking on the enhanced or unenhanced video kicking of a gun? Yes, sir, Justice. I mean, yes, ma'am, Justice.
I was just going to ask a question. As I understand it, your complaint is that this recording that was admitted into evidence had some noises on it, and the prosecutor was telling the jury, listen to the tape and see if any of the noises you hear are the cocking of a pistol. Am I correct so far?
I'm almost, okay. Chief Justice.
Okay. And then the prosecutor cocked the pistol during his closing argument, which made a sound, and he's saying, basically, compare the sound that I just made, cocking the pistol, with the sounds you hear on the recording, and see if what you heard on the recording was, in fact, the cocking of a pistol. Is that right?
Yes, sir.
Okay. And your objection is because the prosecutor is the one who produced that sound, and it was not a witness who had cocked the pistol?
Absolutely.
All right.
It's that, Chief Justice, and also the fact that there was no evidence in the record. And if you look at all the cases that talk about what misconduct is, it talks about what was the evidence in the record. And just like in one of the cases where, I don't know if it was Fan, Brooks, Lie, or whichever one, but they said the color of the car is this color, and it wasn't. And there was no other testimony. And here, the judge said, well, the tape's in evidence, so the jury can use their common sense. Well, the jury had an unenhanced and enhanced tape, and the clicking noise that you hear on there, you can't tell if that's from the clicking of a gun or clicking, the scuffing of it. And you'd have to listen to the recording yourself, and the jurors did that for 2.5 hours until they changed from unintentional to intentional. And there was no testimony. So how can they use their common sense when they put on a firearms expert to say the gun's in perfect working order, and that it takes 3.5 pounds of pressure to pull the trigger, but then not ask the firearms examiner? You know what clicking sounds like? You ever heard a gun cocking? Now, did you take this gun, cock it, and listen to the tape, unenhanced or enhanced, and see if it was similar to that? No evidence of that, sir.
I'm sorry.
Was the gun itself admitted into evidence?
Yes, it was.
So if the jury had been allowed to take the gun back in the jury room, as they often do, photographs, other exhibits, and if the jury had been asked by the prosecutor, when you go back in the jury room, listen to the tape, if you want to cock the pistol and see if the sounds are the same cocking the pistol and on the tape, would you have any objection to that?
Absolutely. Again, because there was no, because of the fact that there's testimony that the noise on the tape is messed up, and that noise is clicking, and it could be a gun or it could be it's a click, click, click. You got to hear it. And it's because of that I object. Because if it hadn't been for this enhanced tape, if it hadn't been for the operator saying the scuffing noise on the tape, I'd have no objection at all, because they could have done it. But when the witnesses aren't asked, the expert witness that handled over 400 firearms isn't asked to compare it. How can you expect 12 ordinary citizens to then compare when they're not even told, hey, by the way, there's enhanced clicking on this tape, and we enhanced that tape. So the clicking that was a little bit of clicking is now a lot louder clicking. And say, is that a gun cocking, being cocked, or is that clicking? The jury wasn't told that the tape had scuff noise on it and microphone problems. So that's why I objected, because there was, not only was there no evidence in the record that the clicking on the tape was in any way related to a gun being cocked, when the state had a firearms expert there that could have said that. But number two, the state knew that the guy that enhanced the tape talked about the scuffing and the noise from the microphone on the camera, as is in Exhibit A for the new trial. So for those two reasons why I objected, Chief Justice.
Okay, thank you. Justice Moritz, you had a question or two, I believe.
Well, what difference would it make? I guess I want you to focus in on, let's assume you're correct, and let's assume that that's what the jury was doing, and that we can make that assumption somehow from the record. What difference does it make ultimately when there was a tremendous amount of testimony from several individuals who I don't think you challenged their credibility, saying that the defendant had indicated his intention to go and kill his ex-wife. And the only reason this business about whether the gun was cocked matters or not is because his story was that he had the gun cocked and ready because he was going to shoot himself, right? And that he had driven around with the gun cocked for 3 months. What he testified, or what his story was?
Since his prior incident.
And something about because he was keeping it cocked and ready in his truck for a fire, in case there was a fire or something.
Well,
I mean, this was all, what I'm pointing to is this was all about his credibility. And ultimately, couldn't he have had the gun cocked and ready because he was going to kill her, which was what other witnesses testified to anyway?
well, I'm glad you asked that, because no, that isn't what the witnesses testified to. If you look at the record, they said he made comments, maybe he was going to kill her or harm her, but they took it to be his drunkenness and his state of mind, and they had no concern that he was going to act on that.
Well, they certainly did indicate a concern, and in fact, the sister-in-law had her husband, his brother, go over to the house to make sure he didn't come over there. She also said she was going to call the police if he did go over there. There was concern. I don't know how you could say there wasn't, but my point is, certainly there was testimony to support that he was going to shoot her, that was his point, and that's what he was there for. And why does it matter whether he had, couldn't he have had the gun cocked because he was going to use that one bullet to shoot her?
Sure, he could have, but if you look at the record, I specifically asked the witnesses, did you think he was going to kill her? Did you believe he was going to kill her? Did you believe that statement was he was going to kill her? And the responding answer was no, no, no. And she didn't say she was going to call the police if she came over there. She said if he was concerned he was going to harm her, she would have called the police other than her husband. But he could have had the gun cocked to go over there. Yes, Justice Moore.
I understand you're making a jury argument, and I get that. I'm just trying to get you to isolate what. And
why I'm isolating it is because the coroner's testimony, that showed doubt of what happened by the state's theory, and it harmed the state's theory because Mrs. Shoemaker was higher than Mr. Shoemaker, and she was shot with the bullet going upward, front to back, left to right. He had plenty of other weapons. He could have killed her if he wanted to. And yes, he could have had that one bullet and just said, well, you're dead, boom, and shot her. But that wasn't the coroner's testimony. That wasn't the facts. And the only statements of the witnesses, yes, he made those about that he was going to harm her. But the ones that knew him best, 32 years, 27 years, said it didn't matter. And also, this was a gun he bought in college when he was 21, 20-some years earlier, and the bullets were old bullets from 21 years older. And he had one left. And as he testified, and others testified, that was considered his way out. So yeah, he could have been over there to kill her. But if you take the fact that he waited till after the school bus was supposed to pick them up, number one, or the neighbor took him. Number two, he stayed on the front porch. He never went in the house. And he said he did that so he wouldn't be a mess to clean up. People that have suicide do things like that, and that are committing suicide, and the jury can weigh it. And those 6 jurors that were considered divided after several hours of deliberation about the unintentional versus intentional, then they listen to the recording and they say, well, it must have been clicking. Yeah, he must have cocked the gun before he shot her. His credibility shot to hell.
Mr. Rourke, did I remember correctly that defense counsel cocked the gun in closing?
Not me. The state did, Your Honor. No way did I cock that gun. Absolutely, positively not. The state did it in rebuttal, so I wouldn't have had a chance to cock it. There was no mention of cocking the gun at any time before the rebuttal testimony, not even in the case in chief. So how can you put on evidence to something that you have no evidence, anything in the record to use, other than you have the recording itself? And just to give you a quick example, I was in a jury trial in Johnson County 3 weeks ago, and it was road rage, and the guy charged with ag battery, deadly weapon.
Is this going to be in our record on appeal, counsel?
No, just an example purely for purposes of illustrative how a judge ruled.
Well, you're well out of time. Can we save the example for your rebuttal?
That's fine. I will, Chief Justice. Is there any other questions? I'm out of time.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. The reason I thought that perhaps defense counsel had cocked the weapon is based on page 404 when he says, but if it's cocked like this and I move the gun around, I could be wrong. I was reading a cold record. I don't know one way or the other on that one. But as to whether or not the gun was cocked during the evidentiary portion of the trial, was indeed actually done on page 484, that if, I believe it's the gun expert testifying, he says, and he goes through and he's just demonstrating to the jury exactly how the gun would be used and the amount of pressure. And he specifically says, I had it here, and then of course I can't underline it. So what happens is I will push it forward on every chamber, and then I'll let it down, I'll cock it back again, load up another chamber, push it forward to see if it'll push off. The cocking was in evidence. Furthermore, as this court has already noticed, or questioned the defense on, the gun was submitted back to the jury. In fact, defense counsel sent gloves so the jury would be able to mess with it. Both the original audio recording and the enhanced audio recording were played in front of the jury. The gun was cocked in front of the jury. The fact that the clicking noise was the gun cocking, that was a reasonable inference. There was simply no misconduct part of the prosecutor in this case, based on that reasonable inference.
Well, is that a reasonable inference? I mean, the fact that the gun was cocked in front of the jury is one thing, but to tell the jury that the sound they're hearing on the recording is the gun cocking, that takes another step. And is that something the prosecutor can make that step in closing argument?
The prosecutor and the jury are equally equipped to be able to determine whether or not they think the clicking noise matches. That is absolutely a reasonable inference that any person can make. I can sit there and say, I clicked a pin. Does that sound like a clicking pin? We can all do that. There's nothing.
But there's another inference they have to make, and that the fact that they sound alike, that they also were one and the same thing, that it wasn't some other sound. There's a third connection they got to make, which is even that it not only sounded like a clicking, but it was the clicking. Does that make sense?
But the prosecutor doesn't have to rule out every alternative theory in order to make a reasonable inference. To make a reasonable inference, the prosecutor just has to say, they sound alike, it probably is the cocking of the gun. I can't see how that is not a reasonable inference on the part of the prosecutor. I think at one point she gasped, and they say she gasped. Can we not make that inference either? Because no one specifically testified that was a gasping. That's allowed, so I don't see the difference between that and the clicking. I'm going to also, and in the brief, he points out, well, had we done it earlier, if we'd had an expert put on to say, yes, that is the clicking, the cocking, he could have rebutted that. That doesn't have anything to do with whether or not there was prosecutor misconduct. His ability to provide a rebuttal has zero impact on reasonable inference of prosecutor misconduct. In his motion for a new trial, if he had a witness that could have disputed that it was the clicking, he could have put that on. And in fact, in order to grant the motion for new trial, he would have had to do that because he can't prove prejudice until he can actually find an expert or anyone else to say, no, that wasn't the cocking of the gun. And then on the justice for the victim, I recognize that this court has said that the prosecutor is not allowed to argue justice for the victim. I respectfully disagree with that argument, and it is usually based on the argument, I'm going to pronounce the case Nguyen, because that's how I was told it was pronounced, Nguyen, I don't...
Nguyen.
Yes, that case. I'm going to say Nguyen, if that's all right. That case doesn't go so far as to say the prosecutor can never ask for justice for the victim. They say the concern essentially is whether or not the prosecutor is trying to get the jury's sympathy. Well, in this case, the prosecutor specifically said, sympathy does no good. Don't rely on sympathy in this case. So that concern is not present in this case. So simply asking for justice for the victim, which... But
that's wrong. That's wrong. The prosecutor does not represent the victim. The prosecutor represents the state of Kansas, and it's obtained justice for the state of Kansas and all its peoples, not the victim.
Right, but that also is through obtaining justice through the victim. They're not something you can separate out. The reason we're in that courtroom is for the victim, to get justice for the state because of the victim.
Well, I guess we could have differing opinions, but if the prosecutor represents the state of Kansas, it's to enforce the rule of law, not to obtain justice for the victim. That's a civil case can do that for the errors of the victim.
The civil case, I don't know if monetary justice, yes.
Well, but be that as it may, the prosecutor, you would agree the prosecutor represents the state of Kansas.
I do absolutely agree with that.
And not the victim.
The victim is right, yes. But I do think it is hard to divorce the two, and that's why the court in Wynn said the central issue should be whether or not they're asking for sympathy. Here they weren't. There was no prosecutor misconduct, but even if there was very strong, if not overwhelming evidence in this case. There were multiple threats against the victim, and I get that defense counsel thinks that family didn't believe the threats, but they took actions inconsistent with that. They tried to protect Anne from her ex-husband in this case, and they wouldn't have done that if they thought, oh, he's just kidding, ha ha ha, or if they weren't serious about the threats. Then, after he apparently supposedly was trying to kill himself, instead of rendering aid to his very hysterical children, he walks away calmly, goes to the sheriff's office, and chuckles. This is all inconsistent with the suicide. The evidence here supports first-degree murder, and nothing the prosecutor said would have impacted that evidence. So the state would respectfully ask that you confirm the conviction in this case. Convictions.
Any questions of counsel?
Can you address the jury question that came up about convicting of second degree? Can we convict of second degree? Apparently they were kind of hung up, and they asked about convicting of second degree. Mr. Rourke says after that's when they watched this video, and then we're able to come up with this.
One, as you pointed out, there are no affidavits in that, so I'm not really sure how strong that evidence is because we can't rely on evidence of statements of counsel. But even if the jury did listen to that tape over and over again, the tape also has other value besides just hearing a clicking. But I still don't see how that was prosecutorial misconduct to have them play the tape. So the number of times that they played the tape really has no impact if there was no prosecutorial misconduct in the first place.
Any other questions? Thank you, counsel.
Thank you. And in rebuttal, Chief Justice, I should apologize. I took your question to mean during closing argument, did I cock the gun? And my answer is emphatically no. The statement referred to by the prosecutor, or the Solicitor General, page 484, that's examination of the firearms expert by Mr. Carr. And on page 484, I don't get into my cross-examination until 501 on the record. And I haven't finished reading it yet, but I may have asked the officer questions and I may have handled it on my cross. I don't know. I just found it. But if I did, it would have been when that person was testifying, sir. And the question that the state brought up, page 484, that's the prosecutor asking the expert to take the hammer back and show the jury how they tested it and to show him how it works. And it's the expert saying, now I've cocked it. And so you would have heard a click then, and that would have been the time to say if there was any question about cocking on the tape. Well, sir, you're cocking that now. Now, have you listened to this recording? And Justice Morris, the recording that was in question was just audio because they took the video and made some exhibits, and then they took the audio and made some exhibits. So it's only audio. So the jury just played this disc over and over and over. And that's what the judge told me. I never got a chance to talk to the jury. And so I believed the judge, and that's why I said it in my motion for new trial, because he told me that. And so I figured what he said it happened as an officer of the court. But the firearms expert does cock it and does put gloves on when he's there, and that's why I gave the gloves, is because he said earlier in his testimony, you got to have those on when you're handling it. I didn't give the gloves for the jury to go back there and cock it. But anyway, he talks about the hammer resting and the very small notch on the hammer. And so that's questioning by the state. And I don't know, I haven't read 501 to 508, but I don't think I did cock the gun. And if I did, it would only have been in response to questions he had about how much took to pull the trigger. It had nothing to do with the sound of cocking of this gun. Doesn't in any way relate to the tape, because there was no issue, Justices. Any time for the year prior, there was never a question that there was sound of cocking of a gun on the tape. It only came up in rebuttal of the state's case. That's the first time it's mentioned. There's nothing about this in any of the state's case, any of the state's witnesses, anything in the reports. There's nothing about cocking noise on the tape, and I only got 37 seconds left. So I'll tell you, the example I had was aggravated battery. The guy says I drive from this grocery store in Lenexa to 87th Street in DeSoto. I took this street, and the question was whether he was doing 39 miles an hour going down one hill. Right before closing argument, my client said, hey, there's two hills on that route. Well, I said, well, now's a fine time to tell me, that no more evidence goes in. And so I'm arguing. I said, well, let me see what I can do. So in argument, I say, well, judge or jury, there's a road here, and you can use your common sense. You know it runs from here to here, and there are two, and before I can say hills, the state objects. So they knew what I was up to. The judge said, well, there may be two hills, but it's no evidence testifying that there were, so it's not in the record. You can't ask them that. That just gives you the opposite side of looking at things. So that's all I want to tell you. It doesn't mean anything on this case, but it's just an example of how things are. If there are any other questions, I'll let you go to lunch. I mean, not let you go, but I'll leave so you can go.
Any more questions? Thank you, counsel.
Thank you.
Thank both of you for your arguments this morning. The court will take this matter under advisement. That concludes this morning's docket. Court is in recess until 9 o'clock tomorrow morning.